We'll call next the case of Mercury Insurance Company versus Markham, and we'll hear from counsel for the appellant.
May it please the Court, Elizabeth Russo on behalf of the appellant, Mercury Insurance Company of Florida. I'd like to reserve, if I may, 3 minutes for rebuttal.
All right.
We are here seeking reversal of the judgment that was entered in this declaratory judgment action. That came up, this issue, that's the key issue, came up on cross motions for summary judgment filed by the parties. And the issue is whether there's any coverage under the Mercury policy. The reason that there was a coverage question is that Mercury had rescinded this policy and returned the premium to the insured immediately upon learning that there had been a material misrepresentation in the application. The Florida law.
When did that occur vis-a-vis the accident the claim made?
The accident occurred on July 13th of 2002, and in the adjuster calling the insured and asking him some questions about it and about the vehicle, learned in early August, learned by August 2nd that there had been this misrepresentation about whether the vehicle had been modified, and it was on August 2nd of 2002 that the rescission took place.
So you would agree the accident requiring your company to pay was really the impetus behind the rescission of the policy. It wasn't just some sort of audit that you went out and saw the truck and said, oh my gosh, we should have never insured this.
It was the occasion for them finding out that there had been a misrepresentation. It wasn't that the accident occurred and then they didn't want to pay. It was that that's how they found out about the modification to the vehicle that had not been represented correctly on the application.
Can I ask you a question? I think this is a pretty straightforward case, and we know the very limited factual record, which is undisputed. I looked at the definition of modify, both in the appellee's brief and in a different dictionary, Webster's Third International. It actually has two meanings in regards to this case. The fourth definition under the verb modify is any minor change in a product or substance. The fifth definition is a major structural change, and it uses as an example the engine was modified to become a locomotive engine, which would seem to play into the appellee's argument that modify means a significant change, to change the use of the product. But the previous definition, the fourth definition, would apply to any minor change, which would seem to go in your favor. And yet those are two definitions of the same word. Do you have any comment on that?
I assume Your Honor is referring to some dictionary that has
Webster's Third International.
But I think that the key thing here is that that goes to how material was the modification. The word modification itself was really not a problem for anyone. It refers to some kind of a change, at least. But most importantly, it was not a problem for the insurer.
I understand that, but don't we look at it as by an objective standard, not subjective?
No, because this insured never – if this insured had come in and said, I had no idea that putting a lift kit on and large –
So it depends on the understanding by the insured?
I think that would have to be the first trigger, is that somebody who was a party to the contract would have to say, I didn't understand that when I read the application. But that's not the case. This insured did understand that he had modified his car, and he didn't put the right answer down. And when he was asked that, he very straightforwardly said –
When you say material, what do you mean? Material to the crash? I mean, in other words, that this change had to have –
No.
What do you mean by that?
I mean that there is an issue when there is a policy that's rescinded based on a misrepresentation in the application. It has to be material to the risk. And then that's defined by the statute as it would have caused the insurer not to issue the policy or to issue it at a higher premium.
If I had a big SUV and I put some of those fancy wheel covers that spin around backwards on it because I like the way they look, would that be material?
I don't think it would be material, but I think it would be a modification. Which is why I think the policy says if you have any modification, or the application says, is the vehicle modified? If the answer is yes, please fill in below the details. So
But
that-
anybody, I guess, though, by your argument, anybody who makes any sort of I mean, I don't modify the car. I mean, I like the way it comes from the factory. But there are a lot of people who like to kind of put their own personal touch on a car or a truck. And I guess if your argument is correct, anybody who does anything runs the risk of losing their insurance. You put a new grill on the car, you know, you're going to run the risk of losing your insurance.
Well, no, I think there's two different things going on there. One of them is the word modify ambiguous? That's the only argument that was ever made below. And I'm disputing that it is ambiguous. Whether a risk is material, whether the misrepresentation or whatever it is, if you say, no, I didn't modify it, or that's your answer, and the modification was, as you say, putting on fancier tire rims that spin around, then there is a fact question about was that material to the risk if the insurer after the fact were to say, all right, you didn't tell us about that. I think there would be a fact question there. But there has never been, in this case, a dispute about the materiality of the modification that was made here. The underwriter...
Mercury never had any doubt about it, but there was no dispute about that?
No. It went in, well, the underwriter gave an affidavit that this was material to the risk and we would not have issued the policy, and in fact they had underwriting guidelines, which we've cited, that long pre-existed this accident that showed the same thing. And the law is, and I know the Carter case from this court, and we've cited other cases in our briefs, the law is that if the underwriter comes in with that testimony and no one ever raises a dispute to it, and no one did in this case, then as a matter of law, it's material. The materiality has been determined.
Back to the, excuse me for interrupting, back to the question of the alleged ambiguity. Assuming we find materiality is not in dispute, which you noted in your brief, we have two different definitions of the word modify. Actually, there are multiple definitions of the word modify, but those two, I think, are the ones that are most significant here, in my view at least. And I looked at your brief and the cases, especially out of the Supreme Court, to talk about there has to be a genuine ambiguity. I understand that. That would seem to me to be an objective standard. Would you agree with that?
That there has to be, well, it leaves it to, yes, then to the court to look at.
Because you would certainly be here arguing if the insured had been recalcitrant and refused to acknowledge any kind of change in his truck and said, no, that doesn't mean modify. I mean, he can't decide the question, right? We have to look at it objectively.
Yeah, all right, I agree in that sense. I think my point was that it's not really raised in this case because, as between the two parties to this insurance application, neither of them had a question that what was done to this truck was a modification. But I understand that what you're saying is, and where that...
Would you agree the issue here is whether that question in the application is ambiguous, regardless of what he thought? Is that question objectively ambiguous, and if so, then your company is liable for coverage? Is that a fairly fair-minded, straightforward statement of the issue here today?
No, I can't agree with that because the person that's raising this ambiguity issue is a stranger to this whole contract. They're coming in and interjecting it after the fact.
Well, you're not arguing standing, are you?
No, I'm not arguing standing, but what I'm saying is that the facts, the undisputed facts in the case, are that both the insurer and the insured understood that this was a modification.
Well, wasn't there testimony from the agent in Lake City that she didn't think a lift kit or a jacked-up pickup truck, to use layman's terms, was modified under the contract? Wasn't there that evidence in the record?
Yes, there was.
So how is, I mean, she's a representative of your company, is she not?
No.
So why isn't she?
She was acting as a broker in this case. But it really doesn't matter if the insured understood. The insured is the one that's responsible for what goes on the application. And he understood that putting the lift kit on and the large tires was a modification, and that if he had been paying attention to the question, he would have said, yes, it was modified.
Looking at it objectively, how can we square that assessment of modification? I mean, common sense, I agree with you. I would say, yes, that truck is modified. But we're looking at it objectively, and the policy itself provides coverage for custom parts and equipment, which are things that are permanently installed, alter the appearance or performance of the car. How is that not creating an ambiguity in the policy, saying we won't cover modified cars, which we determine to be jacked up pickup trucks, yet we provide coverage for components of the jacked up pickup truck? I mean, how is that not an internal ambiguity?
Because in the application it says, has the truck been altered, or the vehicle been altered, modified, so on. If the answer to this is yes, please explain. And in the section provided below, and there is a section provided below. So it may be that adding some of the things that you just listed that they ultimately end up insuring for, they look at it and they say, all right, we don't have a problem with that.
I thought it said if the answer is yes, do not bind, do not issue coverage.
Do not bind and explain below, is what it says. And there's a place right below that has an explanation.
Back to your answer to my last question. Are you suggesting, because I didn't take this from your brief, that the appellee cannot argue that the policy is ambiguous? That whole argument is not in play here because he represents the third-party plaintiff?
I'm saying that the issue has been very artificially interjected into the facts of this case because there wasn't any question about the person who applied on the part of the applicant.
Would you state what you think is, I looked at your issue again, would you state to me what you think the issue is in the case? If you were to just to formulate the issue. I know it's I'm not asking you to recite your issue from the brief from memory, but what is the core issue of this case then if it's not whether the term modify is objectively ambiguous?
I think that the core issue of the case is whether the rescission shouldn't have been honored because the insured acknowledged that there was a material misrepresentation in the policy, in his application for the policy. He knew it. And I
wasn't
think
there also
because
some
of our
evidence,
position,
either in his deposition or somewhere else, where I guess you would characterize it as he backtracked from that initial acknowledgement and said, oh, no, I thought modified, I understood that in conjunction with rebuilt, salvaged, souped-up race car, something to that effect. Wasn't there testimony from the insured as to that?
Well, on cross-examination by plaintiff's counsel, who attended deposition of the insured, the deposition prep of the insured, the question was asked, well, do you really know what modified means in this insurance, sophisticated insurance background sort of way? And he says no. And then he's asked the question about, well, what do you think modified? Well, I know there's modified in connection with racing and everything, but I don't even think that's inconsistent with his having said, was it a modification to put on these big tires and a lift kit? And he said that was a modification. He understood that to be a modification. That's the one that we care about here. Not whether you can also make modifications to make race cars, not whether if someone asks you the question, gee, do you know what sophisticated insurance people mean by modified?
But
doesn't matter. He knew what it meant.
But isn't that what we're being asked to determine? What does this policy mean? Was this application ambiguous as to modified? And, common sense walking around people would think, yeah, that truck is modified, but would you think it's modified? And does he know, and as I understood that deposition testimony which you recited, he was saying, I don't know what they consider to be modified. I consider this a modification, but...
Well, he considered it to be a modification, and so did the insurance company consider it to be. I think the question here is, should the rescission have been given effect? Because they both knew.
You call it a rescission, but really just like a denial of coverage, isn't it? I mean, is there a difference in your mind, or is there not a difference in your mind between learning of some facts, rescinding a policy, sending the premium back, and saying to an insured, we simply do not wish to insure you under these circumstances, on the one hand, and on the other hand, after an accident, just simply refusing to pay a claim? I mean, isn't your case more like the latter?
No. No, I mean, this was just, as I said at the beginning, this was when they first found out, and they would not have. They're not interested in just rescinding policies all the time. This was something they would not have insured.
Well, the rescission, what I'm driving at here is the rescission seems to me to be kind of like a decision whether to insure or not to insure, whether to continue with the contract or not continue with the contract. You don't continue, he can go somewhere else, try to get some assigned risk or whatever he wants to get. But in that decision, I can see how the adjuster might have or your agents might have the ability to say, we think this was the unilateral authority to say, we think this was material. But now the question of materiality is not for you, it's for the court, isn't it?
As to whether the
Whether this
rescission,
modification was material is really not a question for the insurance company after the accident. It's a question for the court, isn't it?
well, yes, except that it's become a matter, here, it was not disputed. It was never disputed that it was material.
Well, I get your point on that, and we'll add a little, I consumed too much of your time. We'll add 2 minutes for rebuttal, and we'll give Mr. Rosenblum an additional 2 minutes. No, there's no law that says you need to use it. But you know that. I don't need to tell you that.
I do. May it please the Court, Louis Rosenblum for Mr. Markham. Let me make one point absolutely clear. The question whether the application was ambiguous is one for the court. It doesn't matter what Mr. Roberts said, Mr. Markham said, doesn't matter what the agent, Ms. Carr, said. If the application question was ambiguous, there is no incorrect answer. The case law is very clear on that.
But, I mean, in making that objective determination, don't we just kind of have to check our common sense at the door? I mean, I've looked at the pictures. I can't fathom any rational, reasonable person answering no to a question as to whether that truck is modified.
Well, let me make the comment that I made in 2006 that Judge Thomas took some dispute with. You got to put this in perspective. This is Lake City, Florida. There is nothing unusual about a pickup truck with big tires and a lift
love
kit.
jacked up pickup trucks, and I understand there's nothing unusual about it, but how could anybody answer the question, no, it's not modified? I mean, you can look at it. It is modified. It may be a modification that's very common in Lake City and is a nice-looking pickup truck, but, I mean, how you get from the picture to a no answer just boggles my mind.
Well,
and I guess my question is, is this just a situation where the law, requires us to check our common sense at the door?
Well, we're lawyers. We understand terms like alteration, modification, amendment, but the average insured doesn't understand what those words mean. But I'll tell you what he does, that they do understand terms like customized, dune buggy. They understand that. If the question said, does your vehicle have a lift kit, well, it would have been a lot easier to answer yes or no. I cited this Latin term that I wouldn't even venture a pronunciation in my brief about judging the words are judged by the company they keep. And look at the company here. Rebuilt, salvaged, customized, and then if you go to the agent's manual, they add dune buggies. Those sound like changes that make the car no longer street legal. It doesn't sound like bigger tires, or, as pointed out in the deposition, smaller tires. Those are popular, or the rims that spin around. But according to Mercury, and I haven't heard Mercury give a definition yet for the word modification. Not in the briefs, not in the argument. They've never defined it. So if they're including every possible change, anywhere from the dune buggy conversion to the university decal.
Counsel, what do you say to your opposing counsel's argument that we're really not here to decide the objective, genuine ambiguity, but really this issue is just whether or not the rescission should have been honored by the trial court? Opposing counsel seems to be rejecting the entire thrust of your brief and your argument that the term is ambiguous, and stating that the insured found that he knew what the term modified meant, and he said so in his deposition in no uncertain terms.
I respectfully beg to differ. He didn't exactly say that, and somehow Mercury thinks cross-examination by your own attorney doesn't have any weight.
What do you say to the argument that, it's almost, as I understand it, like a standing argument, but the argument that you're a third party interjecting yourself into the case in that the insured understood the term, said it was modified in the deposition with the lift kit, yes ma'am, the bigger tires, yes.
All right,
That's the exact answer, and it's obvious, and I'm very open-minded about this term because it has layers of definition. in English is that it's obviously modified. I mean, there's no question about it. The tires are huge. The truck has been changed. It's been altered, changed, and in those terms you mentioned, it also includes specialized. This is a specialized truck.
I don't know what a specialized truck is, Your Honor, and I don't know what, beauty is in the eyes of the beholder. Modification is in the eyes of the beholder. But to answer your question directly, Mr. Markham holds the case on assignment from Mr. Roberts, so he stands in his shoes. Whatever Roberts says, we're responsible for. But if you read his deposition, and here again, this is a fact question I don't think we need to get to, but in one place he does say it was modified, but he later, as I think Judge Padovano pointed out, he backtracked from that. He said he said he didn't read it, but he said the word is vague. I don't understand all the legalese I'm being asked on this deposition. And then Mercury says, well, he admitted it was modified when he gave his statement to the Mercury adjuster. But if you read the statement, this is interesting. The adjuster said, was your vehicle modified in any way? Now, if this application had said modified in any way, that changes the meaning altogether. And you have a question, but let me show you an additional reason why it's ambiguous. The insurance company says, well, you put down yes, even if you've just added some fuzzy dice to your window, and then you are supposed to fill in the comments. Well, that's not what the application says. It says, if yes, do not bind and explain in comment section below. So if you're this, and please excuse this expression, this good old boy from Lake City, he's in there to get his truck insured, and he says, what do you mean do not bind? What does that mean? You're going to tie me up? That's obviously written for the agent. The agent's the one that puts things down in the comments, not the insured. This application was not designed for that. And then what about the word where they meant to say specially built, they said specifically built. Well, what is a specifically built car? I'm just telling you, the whole thing is fraught with ambiguity. But the important thing to remember is if it's susceptible to more than one reasonable interpretation,
And that's
it's ambiguous, case over.
And that's interesting. Again, the definition of the verb modify has multiple meanings. There's no question about it, in my view. You cited it in your brief. Another definition, another dictionary confirms that. Is that then, as a matter of law, ambiguous?
Well, you don't have to rely solely on the dictionary.
I'm just asking you in your view.
Yes. And we've cited cases. We've cited the two cases in our brief that involve the word driver. And there was an ambiguity about whether that meant the drivers that live in the household or anybody who might be driving the car. I don't remember the specifics. But the courts in those cases made it very clear that if the term in the application is ambiguous, there is no wrong answer. There is no misrepresentation.
But the company cited a case from the 2nd District where an insurer told the company there was no other adult drivers. Her ex-husband was living in the house with his brother. There were other adult drivers in there in the household, and the 2nd District reversed and said that was a misrepresentation.
Well, every
completely
application,
different than the other cases.
every application you have to look at the terms, and I admit that. But the point I'm making that if the court in the 2nd District case you cited found no ambiguity, but if the court does find an ambiguity, the case is over. Mr. Markham wins, because if it's ambiguous, there is no misrepresentation, because there cannot be a wrong answer.
Let me ask you this. I mean, I generally have very little sympathy for a situation like this, where a premium was paid, coverage was provided, accident occurs, looking for any loophole, technicality to get out of providing coverage. But here, don't I understand the accident correctly, that what happened was the insured loaned his truck to a buddy, and his buddy was driving outside of a bar and ran over somebody's foot, such that it seems reasonable for me to infer, if that's all the facts we have, that the reason he ran over his foot because he couldn't see him because he was in a jacked-up pickup truck with wide tires. So with all that said, what do we know about the accident? And I understand it's probably not pertinent to our
we know what
resolution.
you just said, but in all due respect, Judge, that is not where we should be directing our attention.
I understand that.
It's easy to say that, sure. What about the case that I cited from the 3rd District, where the insurance company accused the insured of lying about her history of cancer. And she died of cancer, and you should say, aha. But the fact is that because the question on the application was ambiguous, the court ruled for the insured because there is no incorrect answer. So it really, in all due respect, doesn't matter how the accident happened. I'm not even sure that that's in this record. I know at one place the Mercury put the accident report in the record, but
you think that Mercury would have been within its rights to rescind the policy and return the premium on this ground if they had learned of this before the accident? Let's just, this had nothing to do with an accident, just an insurance contract. Would their willingness to continue with an insurance contract?
Well, I don't know if that we would never litigate that. See, they do their underwriting after the claim.
Well, see, that's my concern. It seems to me that there's got to be some big difference between rescinding a policy and simply denying coverage.
The only difference is that a rescission, they give you your money back. And it doesn't continue for any future time frame. That's the difference. So what they're saying...
It seems to me that calling this a rescission improves Mercury's position somewhat, but I confess to you that I don't really know why.
I don't think it makes any difference whether it's a denial of coverage or a rescission. The only question before the court is the clause ambiguous, or the application? And if it is ambiguous, the case is over. If the court finds that it's not ambiguous...
Before you get there, in evaluating whether it's ambiguous, are we constrained to the four corners of what the insured had in front of him, or should we be looking at the policy and the underwriting guidelines, things obviously the insured did not have, but things that we have in our record?
I think the Hornbook law would be that you're confined to the four corners of the policy, but the policy includes not only the application, but the actual insurance policy that was issued, which includes, as you pointed out, provisions giving coverage for the very parts they say makes the risk uninsurable. So I think you have to limit your analysis to the policy, and we've cited a case in our brief, and there's one in the trial court's order which states that the policy includes both the main policy and the application read together.
On the point of the provisions in the policy regarding these type of equipment being covered, do we have anything from the underwriter's affidavit saying, yes, we would have covered, but it would have cost more? Or is what we have, no, we would not have covered because of this modification?
I think they said, no, we would not have covered. And understand that the materiality issue has nothing to do with whether the application is ambiguous. What their underwriters have said, had we known this had a lift kit, we wouldn't have written the policy. Well, I mean, we can't rebut that. That's what they say. I mean, theoretically, you could get your own underwriter.
My point is this. If I understood counsel's argument correctly, she was saying, well, the only reason those provisions are in that policy is because to get coverage, you would have had to pay a higher premium, which we would have known about had you answered yes. And so that's why I was curious about what the underwriter said. It would be, if I understand correctly, the record is more consistent with the view that if the answer is yes to modification, the result is no coverage, period.
Well, that's what the application says. The special parts and equipment that are covered for theft and comprehensive coverage, that wouldn't affect the premium for liability coverage. For example, I think Mrs. Dice or Mrs. Carr, she went by both names, the agent, testified, for example, if you had a $5,000 stereo installed in your truck, probably wouldn't affect the underwriting for the liability coverage, but they would certainly surcharge the premium for if you want. But
isn't that different than changing the performance characteristics of the vehicle? I mean, I don't think you need to be a physicist to understand that if you raise the center of gravity of a truck like that, it's going to be a greater risk for rollover accidents and all kinds of other things. I mean, you've changed the performance profile of the vehicle.
Well, I'm not saying that isn't true, and I'm not saying I wouldn't have answered the question yes, But the question is, put this in the context of this young man, I don't know, in his 20s. He goes in there to insure his pickup truck, and there are words like alteration and modification.
But that gets us back to whether this is answered by an objective evaluation, not by necessarily the insured's personality profile, not by yours, not by mine, but whether a reasonable person would have found the question. I'm just trying to ask.
I think it's an objective standard.
Yeah, it's an objective standard, correct?
Yes.
Yeah. So whether a reasonable person would have understood this question to apply to a truck that looked like this.
Well,
That's.
Yeah. It is an objective standard that should be based on the four corners of the application and the policy. But you can, if you find that it's ambiguous, you can rest assured by looking at the record that you would not be alone, because there are different interpretations. The agent, who's been writing hundreds of these policies in Lake City, said she didn't consider it a modification.
But counsel, these are all interested parties one way or the other. The reasonable person.
Well, she was on their side.
Right. The reasonable person standard applies, right? And your brief starts out very helpfully by saying the exact sentence at issue from the policy. And I note that it says, is any vehicle rebuilt, and using your citation to the Latin phrase principle, and it's obviously applicable by case law, is any vehicle rebuilt, salvaged, modified, altered, or specifically built customized? Do you think that word modified, or for that matter altered in that phrase, is ambiguous by the objective standard?
Yes. Yes, because as you point out, the word modified could mean anywhere from a dune buggy to tinted windows.
Put a boom box in it, it's modified.
Absolutely. Any aftermarket stereo. And of course, all the insurance company says, fine, you need to put down there that you've added your favorite university decal, and then go to the comments sections. And I respectfully submit that is not what this insurance company intended, because if you have to put yes for a boom box, you have to put yes for a new stereo, the agent can't bind the coverage. And guess what? The insurance company, the insured, he's not waiting around. He goes down the street to Geico or Progressive, and he gets his policy there. And
isn't that the whole point of the question? Is your vehicle modified? If yes, the agent is instructed not to insure the policy, and the insured or the would-be insured is free to contract elsewhere.
Yes, but we're trying to determine what the insurance company meant here, and I respectfully submit they did not mean for the insured to write down any change that might be made to the vehicle. I think I've used my time. Thank you.
Just following up quickly on that point, using the objective reasonable person standard, an insured coming in and filling in the application is very unlikely when they read, has your vehicle been modified, to think about the dice.
May I ask, do you agree, would you concede that that is the rule of law we apply here, whether a reasonable person would find this sentence, this use of the term modified in this sentence, ambiguous?
As applied to whatever it is, that
sentence, as I just read, is that sentence ambiguous? That use of the term modified, is that ambiguous by a reasonable person standard?
Yes, I agree with that.
And that's the issue we face today, correct?
I agree with that. But I don't think
do you agree that the principle that we'll use the English rather than the Latin, a term is understood by the company it keeps, so we must look at those other terms? Would you agree that's relevant?
I don't think so. I mean,
you don't?
No, I think the modification was the question at issue here. That's what the insured understood. But I think I think you do not answer the question by going to a dictionary and saying, are there multiple definitions? Because there can be for so many different words. And really what it comes down to...
that would lead credence to the principle that's been recognized in many, many cases, that, as aptly cited, you do look at the other terms, unless there's a phrase in there, including but not limited to, which is not in this sentence, which is case law discussing that. But Without that phrase, including but not limited to, you do look at the other terms, correct?
I think you're looking at what a reasonable person would understand reading the question, and what would they fill in response to that. They're not going to fill in dice, and I think if we found out about the dice, we're not going to think that's material, I mean, that that's a modification either that affects the underwriting. I think that's really, everybody knows what they're there for, and I don't see an ambiguity, and the materiality question was decided. Thank you.
Thank you, counsel. We'll be in